There's breaking news just coming into the Situation Room right now. The Georgia election interference case against President Trump and others in their effort to overturn the 2020 presidential election results will continue, but with a new prosecutor. This comes after Fulton County Attorney Fani Willis was previously removed from the case. Let's go live right now to CNN crime and justice correspondent Caitlin Polantz. She's got all the breaking details. Caitlin.
Wolf, a criminal case against President Donald Trump is alive again with a new prosecutor. This is the case in the state of Georgia in Fulton County around the 2020 election, Donald Trump's efforts there, and an alleged conspiracy that he led or is alleged to have led with top officials, including Rudy Giuliani, advisors on his campaign, as well as many people in that state who acted as fake electors. This is a case that had been charged 2 years ago and had been essentially on ice, in limbo. It was not moving forward because the prosecutor, Fani Willis, she had been removed from it earlier by a state court.
Hey friends, Adam here. Hope your day is going well. The courts have abruptly shifted from procedural delays to decisive action, issuing arrest warrants, contempt findings, and surrender deadlines measured in hours. What was once a slow-moving legal machinery has accelerated, and Trump's inner circle is now facing real consequences with no time left for appeals or evasion. The people who surround Trump, the ones who believe that the legal system could be delayed indefinitely, who convinced themselves that motions and appeals and procedural maneuvering could keep the wolves at bay forever, are now discovering that judges have limits too. And those limits are being reached right now in courtrooms across the country where judges are watching an administration and its allies decide whether they are willing to defy direct judicial orders and accept the consequences, or finally acknowledge that the rule of law still applies to them as surely as it applies to everyone else.
The prosecutor handling the Georgia election interference case against President Donald Trump and others said in a court filing Wednesday that he has decided not to pursue it further. Pete Skandalakis took over the case last month from Fulton County District Attorney Fani Willis, who was removed over an appearance of impropriety created by a romantic relationship with the special prosecutor she chose to lead the case. The case began nearly 5 years ago when Willis made public her intent to investigate whether illegal attempts were made to influence the state's 2020 elections. That included a January 2, 2021 phone call in which Trump was recorded urging Georgia's Secretary of State to help find the votes needed to overturn his defeat in the critical swing state. Legal action against Trump was unlikely to proceed while he is president. However, 14 other defendants, including Rudy Giuliani and Mark Meadows, still face charges. The abandonment of the Georgia case closes a chapter in a legal effort once seen as a grave threat to Trump's political future. The federal cases from special counsel Jack Smith on election interference leading up to the January 6, 2021 U.S. Capitol riot and on mishandling classified documents were also previously dropped.
To understand the full scope of what is happening, you have to appreciate just how many different legal pressure points are being applied to Trump's world simultaneously, and how dramatically the judicial posture has shifted from accommodation to confrontation. For a long time, through the first term, through January 6th, through the various investigations that followed, the dominant frustration among those who believed in legal accountability was that the courts moved too slowly, that judges were too deferential, that procedural delays were allowing Trump and his allies to run out the clock on investigations and cases that should have produced consequences years ago. That frustration has not disappeared entirely, but the judicial environment has changed in ways that are impossible to ignore. Judges who were once content to allow delays and extensions and procedural accommodations are now drawing hard lines that leave no room for interpretation. Orders are being issued with deadlines measured in hours rather than days. Contempt findings are being made with language that leaves no doubt about the seriousness with which the courts view the conduct before them. And the message from multiple courts to multiple members of Trump's orbit is identical in its clarity and its urgency. The time for maneuvering is over.
This is one of the most eventful and impactful weeks in the investigation of the U.S. Capitol riot. In a legal brief, the U.S. House Select January 6 committee reveals it has a good faith belief former President Trump and his allies engaged in a criminal conspiracy by trying to block Congress from certifying the 2020 election. This is the first time the committee has laid out a potential criminal case against Mr. Trump. In its nearly 200-page filing, the committee says the former president illegally sought to obstruct an official proceeding and, quote, did so corruptly. The committee is trying to obtain records from attorney John Eastman and is arguing the suspected crime overrides Eastman's claim of privilege. Meanwhile, there are breakthroughs in the criminal investigation of the Capitol siege as well. The first criminal trial against an accused rioter is now underway. The son of defendant Guy Reffitt testified against his father, saying Guy Reffitt scared the family with his political rhetoric, including his use of the phrase "rise up" in 2020 in text messages.
One of the most dramatic and concrete examples of this new judicial posture came in the Georgia RICO case, involving two of the most prominent figures in Trump's post-election effort to overturn the results. Mark Meadows and Jeffrey Clark were not peripheral players in the scheme to reverse Biden's victory. They were at the very center of the operation, understanding exactly how the pressure campaign was organized, executed, and sustained. When both men attempted to use a legal maneuver to delay their surrender to Georgia authorities and move their cases out of state court and into the more favorable terrain of federal court, the federal judge looked at those requests and denied them cleanly and completely. Not delayed them, not sent them back for further briefing, not accepted them provisionally while the legal arguments were fleshed out. Denied them with the kind of finality that left no room for further argument. That denial meant Meadows and Clark had to surrender to Fulton County authorities by a specific fixed deadline, a noon cutoff that was not negotiable and not extendable.
A new indictment against former President Donald Trump. This time he's accused of running a criminal enterprise to keep him in power.
Violations of Georgia law arising from a criminal conspiracy.
Donald Trump and 18 allies indicted for scheming to overturn Trump's 2020 election loss in the state of Georgia. Good evening, everyone. I'm Mike Meebeck.
And I'm Greg Lee. This is his fourth indictment in 4 months. KTVU's Jana Katsuyama has been following breaking details coming out of Georgia tonight. Joins us now with the very latest. Jana.
Greg and Mike, all of this happening very quickly just in the past couple hours. The grand jury deliberated until 8 p.m. tonight, Georgia time. It was almost midnight on the East Coast when the district attorney came out and announced these charges against the former president. The DA released the 98-page indictment tonight. It charges 19 people, including former President Donald Trump, and lists 41 felony counts against him and other top Republicans, including local leaders in Georgia and Trump's White House chief of staff.
The alternative was the district attorney seeking arrest warrants for their physical apprehension by law enforcement. That is not a theoretical threat or a procedural formality. That is a judge telling two of the most powerful former officials in recent American political history that the window for legal maneuvering has closed, and that the choice now is between walking through the door voluntarily and being brought in by force. The message this sent through the entire legal ecosystem surrounding these cases was unmistakable. The patience of the courts had officially run out. The Georgia situation was not an isolated incident, but part of a broader pattern of judicial impatience that has been building across multiple cases in multiple courts. In a separate confrontation that sent shockwaves through the legal community, U.S. District Judge James Boasberg made a finding that fundamentally changed the calculus for everyone watching. After the Trump administration conducted deportation flights that Boasberg had explicitly ordered them not to conduct, after they looked at a direct judicial order and decided to proceed anyway, the judge made a finding of probable cause that the administration should be held in criminal contempt of court. Criminal contempt, not civil contempt. Civil contempt carries financial penalties and is essentially a tool for coercion. Criminal contempt can result in actual criminal charges against actual individuals. The administration had defied a court order, and a judge had responded by saying there was sufficient evidence to treat that defiance as a crime. That moment represented a crossing of a threshold that very few people who followed these matters expected to see reached, and it made unmistakably clear that the judicial system was prepared to use the most serious tools available to it against an administration that treated court orders as optional suggestions rather than legally binding directives. The 24-hour deadline scenario has become a recurring feature of the legal confrontations between courts and the Trump administration in ways that add an urgency and an immediacy to what might otherwise feel like slow-moving legal processes. In one immigration case that drew significant attention, a federal judge gave the Trump administration exactly 24 hours to produce evidence in a detention case involving a man who had been held for years. Not a week, not a month, 24 hours. The clock starts, the deadline arrives, and either you comply or you face the consequences that the judge has the power and the demonstrated willingness to impose. That kind of ticking clock judicial pressure transforms the legal landscape from something that feels abstract and procedural into something that feels immediate and consequential. And it does so because the judges issuing these orders have concluded that the normal pace of legal proceedings has been exploited by the administration and its allies to run out the clock and avoid accountability indefinitely. They have seen the pattern, they have documented the pattern, and they have decided that the pattern must stop. Let's go deeper into what is actually driving this acceleration of judicial pressure and why multiple judges across multiple cases are arriving at the same conclusion at roughly the same time. The answer lies partly in the specific conduct of the Trump administration and its allies in response to court orders, and partly in the broader legal and political context that has been building for years. What judges across these cases have observed, and what the record in each of them documents, is a pattern of behavior that goes beyond ordinary legal disagreement or procedural strategy. It is a pattern of treating judicial authority as conditional, of complying with court orders when convenient, and finding reasons to disregard them when they are not. Section 2. The consequences mount. When judges observe that pattern with sufficient clarity, their response is to stop offering accommodations and start reaching for the most serious enforcement tools they have available. The contempt proceedings against the Trump administration over the deportation flights are worth examining in detail, because they represent the clearest and most documented example of what happens when an administration decides that a court order does not apply to it, and that judicial authority can be treated as conditional rather than absolute. The sequence of events is not in dispute and has been documented in the court record. Judge Boasberg issued an order halting deportation flights that he determined violated his earlier rulings. The administration was informed of that order through proper legal channels. Deportation flights proceeded anyway, after the order was in place and after the administration's lawyers were aware of its existence and its requirements. When the judge demanded an explanation for why his order had been defied, the administration's response was, in the view of the court, wholly inadequate. It failed to provide a credible justification for why the flights proceeded after the order was issued. And in some cases, the administration's explanations contradicted each other and contradicted the factual record that the judge already had in front of him. The judge's finding of probable cause for criminal contempt was not based on a disagreement about the interpretation of the law or a difference of opinion about what exactly the order required. It was based on a documented sequential record of an order being issued, the administration being aware of the order, and the administration proceeding with exactly the conduct the order prohibited. That sequence, order issued, order ignored, contempt finding made, is precisely the kind of escalation that judicial systems are designed to produce when lower-level enforcement measures fail to achieve compliance. And it sent an unmistakable signal to every member of the Trump orbit facing court orders that the judiciary was prepared to treat deliberate non-compliance as a criminal matter with criminal consequences. The arrests and legal proceedings involving people in Trump's broader orbit have been accumulating for years, and the breadth of that legal exposure is part of what makes the current moment feel so significant. Federico Klein, a Trump State Department appointee, was charged in connection with the January 6th Capitol attack, making him one of the most senior executive branch officials to face criminal charges related to that day. Thomas Barrack, one of Trump's longtime allies and a key figure in his political fundraising world, was arrested on foreign agent charges that alleged he had been using his access and influence to benefit a foreign government without disclosing it. These are not peripheral figures or low-level associates. These are people who were genuinely close to Trump, genuinely inside the world of influence and access that surrounds any presidency, who now face or have faced serious federal criminal charges. And their cases are not isolated. They are part of the same ecosystem of legal exposure that has been expanding outward from the center of Trump's political operation for years, encompassing more people and more serious charges with each passing cycle of investigation and prosecution. The political atmosphere on Capitol Hill that has been created by this escalating judicial pressure is itself a significant and underappreciated part of the story. Because what happens in the courts does not stay in the courts when the subject is the president and his closest associates. And the cases involve conduct that goes to the heart of how the American democratic system functioned during one of its most turbulent periods. When Trump himself faced the prospect of arrest in the Manhattan hush money case, when he publicly stated that he expected to be arrested on a specific Tuesday and used that expectation to fundraise and generate political energy, the reaction on Capitol Hill was extraordinary in its breadth and its intensity. Lawmakers were gaming out the political fallout across a dozen different scenarios. Communication staff members were preparing talking points for every possible question. Legal advisors were walking members of Congress through the constitutional implications of a former and possible future president being taken into custody. Media relations offices were drafting responses to questions about whether members believed the former and future president should be treated like any other criminal defendant. The phrase that appeared in news coverage at the time, that the prospect of Trump's arrest hung over Capitol Hill like a storm that everyone could see coming but nobody could predict the exact shape of, captures something real and something specific about the way legal proceedings in multiple courts were generating a political atmosphere of genuine anxiety and uncertainty in a place that prized itself on understanding what is coming next. That atmosphere has not dissipated since then. It has intensified with each new contempt finding, each new surrender deadline, each new arrest of someone close to the Trump operation. And it will continue to intensify as long as the courts continue to escalate their response to the defiance they are documenting in their records. What makes the current judicial posture particularly significant is the way it has forced a confrontation with a question that the Trump administration and its allies have tried very hard to avoid answering directly. Is there any court order that this administration will comply with unconditionally? The record that has accumulated across multiple cases suggests that the answer has frequently been no, that compliance has been treated as a political calculation rather than a legal obligation, that orders get followed when the cost of defiance seems too high, and disregarded when the administration believes it can get away with defying them. Judges across the system have been watching that record build, and the harder deadlines and contempt findings and surrender orders of recent months are their response to it. They are communicating through the most powerful legal tools available to them that the calculation has changed, that the cost of defiance is now high enough that the administration and its allies need to take it seriously. Whether that message gets through is one of the most consequential open questions in American legal and political life right now. The role of the Georgia case in particular deserves extended attention because it represents something genuinely novel in the history of American political prosecutions. A state-level RICO case that caught in its net not just the president himself, but a wide swath of the political and legal operation that surrounded his effort to overturn the 2020 election result. RICO is a racketeering statute that was originally designed to go after organized crime by allowing prosecutors to charge everyone involved in a criminal enterprise, rather than just the individuals who committed specific predicate acts. Applying that framework to the conduct of a former president and his allies is legally aggressive and historically unprecedented, and it has produced a set of legal dynamics that are unlike anything that has preceded them. The fixed surrender deadlines for Meadows and Clark, the judges' denial of their efforts to delay and move their cases, represent a court system that is treating this prosecution with the seriousness and the urgency it believes the underlying conduct requires. That is not a small thing. That is a fundamental statement about how the legal system views what happened in the weeks after the 2020 election. The indictment alleges that rather than abide by Georgia's legal process for election challenges, these individuals participated in a criminal enterprise in Fulton County, Georgia and elsewhere to accomplish the illegal goal of allowing Donald J. Trump to seize the presidential term of office beginning on January 20th, 2021. That is the charge that Meadows and Clark were facing when they tried to delay and move their cases. That is the charge that the judge refused to let them escape through procedural maneuvering. And that is the charge that now hangs over everyone in Trump's orbit who participated in that effort to overturn the election. The message from the courts is clear. This is a serious case. These are serious charges. And the time for playing games with the legal system is over. Section 3. The final countdown begins. So where does all of this leave us, and what should we actually expect from the intersection of judicial pressure, political resistance, and the expanding legal exposure of Trump's inner circle? The first thing to be clear about is what the acceleration of judicial pressure does and does not mean in practical terms. It means that judges are using harder tools. It means that deadlines are real and that non-compliance has documented consequences. It means that the Trump administration and its allies cannot assume that courts will continue to extend the accommodations that made it possible to delay accountability for years. What it does not mean, what no single court order or contempt finding by itself guarantees, is that the people at the top of the Trump operation will ultimately face criminal consequences proportionate to what the evidence suggests they did. The gap between judicial pressure and final accountability is still wide, and it is a gap that has swallowed many previous attempts to hold powerful people legally responsible for their conduct in office. The willingness of the executive branch to enforce court orders against itself and its allies is perhaps the most fundamental factor in determining whether these legal proceedings result in real consequences. The second thing to understand is the significance of the contempt proceedings as a mechanism for accountability that operates differently from ordinary criminal prosecution and that creates a different kind of legal and political dynamic. When a judge finds probable cause for criminal contempt, the target of that finding is not necessarily a person who has been charged with a crime in the traditional sense, who has been accused of breaking a law that was on the books before they acted. They are a person who has defied a court order, who has looked at the authority of the judicial branch as expressed in a specific written, legally binding directive, and decided consciously and deliberately that their own agenda takes priority over compliance with that directive, and with the law as the courts have interpreted it. That is a specific and serious form of legal wrongdoing, and it carries specific and serious consequences that are distinct from the consequences of ordinary criminal charges. But it is also a form of wrongdoing that in the current political environment may be treated very differently, depending on which party controls the executive branch and how aggressively that branch is willing to use its own enforcement mechanisms to carry out judicial orders against itself and its allies. The structural tension there, between a judiciary that has the legal power to make contempt findings and issue arrest warrants, and an executive branch that controls the actual marshals and the actual law enforcement mechanisms that are needed to enforce those findings, is one of the deepest and most unresolved constitutional tensions in the current confrontation between the courts and the Trump administration. The third thing to understand is what the experience of the people who have already gone through the legal process, the ones who surrendered in Georgia, the ones who were arrested on federal charges, tells us about the experience that may await others. What it tells us above all is that the legal process is real. It is not theater. The surrender deadlines in Georgia were not symbolic gestures. They were enforceable orders, backed by the full authority of the court. The people who complied, who showed up at the Fulton County Jail and were booked and photographed and released on bail, experienced something that no amount of political rhetoric could completely insulate them from. They went through the physical, legal, personal experience of being processed as criminal defendants in a serious case. And that experience, that contact with the reality of the legal system, rather than the political narrative about the legal system, is something that awaits others who are currently in the orbit of these investigations. If the judicial pressure continues to escalate and the avenues for delay continue to close, the human dimension of what is happening to the people who are in Trump's orbit and who are navigating these legal pressures is important and often overlooked in the political and legal analysis. These are not abstractions. These are real people with families and careers and reputations and financial resources that are being consumed by legal proceedings that can last years and cost millions of dollars even when they do not ultimately result in conviction. The strain of operating under the threat of criminal prosecution, of having to coordinate legal strategies, maintain political loyalty, manage public narratives, and navigate the competing demands of lawyers and allies and political operatives, is something that takes a genuine human toll. Some of the people in Trump's orbit have handled that strain by maintaining solidarity. Others have broken under it and cooperated with investigators or handed over documents or made legal decisions that prioritize their own protection over the protection of the broader operation. And the pattern of who breaks and when and how is one of the most closely watched dynamics in all of these ongoing legal dramas. What happens next in each of these cases will be shaped by a set of factors that go beyond the specific legal merits and into the political and institutional dynamics that ultimately determine whether legal accountability for powerful people is real or merely aspirational in the American system. The willingness of the executive branch to enforce court orders against itself and its allies is perhaps the most fundamental of those factors, because a judicial system that can make findings and issue orders but cannot compel their enforcement is ultimately dependent on the good faith of the very branch it is trying to constrain, the willingness of the Senate to confirm the judges and prosecutors who pursue these cases, the willingness of juries in specific jurisdictions, Georgia, Washington, New York, Florida, to convict in cases that are inevitably framed as politically motivated persecution by the defendants and their enormous and well-funded legal and media apparatus. The willingness of appellate courts to uphold findings and convictions that will be appealed aggressively and expensively through every level of the judicial system available to people who have both the resources and the political motivation to fight every ruling to the last possible moment. All of those factors will shape the ultimate outcome of a legal confrontation that is unprecedented in its scope and its significance for the future of American democratic governance, and for the question of whether the rule of law applies with equal force to the most powerful people in the country. It applies to everyone else. And the final thing to understand is that what is happening in the courts right now, the hard deadlines, the contempt findings, the surrender orders, the accumulating arrest of people in Trump's orbit, represents the legal system doing exactly what it is designed to do when confronted with sustained and deliberate resistance to its authority over an extended period of time. Courts have limited tools for enforcement compared to the executive branch that commands armies and law enforcement agencies. They cannot deploy military forces or override elections or rewrite laws through their own initiative. What they can do is escalate their response to non-compliance through a graduated series of increasingly serious measures until the cost of defiance finally exceeds the cost of compliance. Until the people who have been resisting court orders conclude through rational calculation, or through the actual experience of consequences that continued, resistance is not worth what it is costing them personally, financially, and legally. That escalation is what we are watching unfold right now simultaneously across multiple cases and multiple jurisdictions, with multiple judges who have independently reached the same conclusion about the necessity of harder measures. Capitol Hill is watching every move. The country is watching every deadline. Legal observers are tracking every contempt finding and every surrender and every arrest. And the people in Trump's inner circle, who are still calculating whether they can outlast the courts, who are still believing that the right motion filed at the right moment will open another path to delay and escape, are running out of time to make that calculation pay off. The courts are moving with decisive speed. Deadlines are real. Contempt findings are on the record, and judicial authority is no longer blinking in the face of political defiance. What happens in the coming hours will determine whether the principle that no one is above the law still holds in America.